We're often asked what is a farm business tenancy, and if we look at the definition of farm business tenancy, that tells us what that is. So if we start with the introduction, farm, that we look at the Act then to agriculture, and that describes what is the nature of a farm, looking at livestock, crops that are grown, etc., etc. And then we look at the next word, which is business. So that use, the agriculture, needs to form part of a business, a profit-making entity. And then lastly, we get to tenancy, same as any other arrangement between a landlord and a tenant. The arrangement can be as concrete or flexible as any party wishes it to be. It all comes down to the terms of the agreement between the landlord and the tenant when we come to document the farm business tenancy as to how flexible those arrangements are. However, as we're putting the arrangement into writing rather than leaving things to chance, I would advise that we always write in any flexibility so that the parties understand where they need to be talking to one another, so that one party doesn't go off on a tangent and do something that the other party wasn't expecting. In order to create a farm business tenancy, you need to have willing parties, a landlord and a tenant. The landlord is the person with the land which will be taken by the tenant in order to farm under the terms of the tenancy arrangement. It is possible to have tenancy arrangements that are verbal, but we would always advise that you make sure the arrangement is in writing, so it sets out formally what has been agreed between the parties. We would look to agree things like the length of the term, the rent that's payable, and what the tenant can or can't do on the land. When entering into a farm business tenancy, we're quite often asked by the tenant whether they should be taking that agreement in their own name or in the name of a company. That has a number of implications for them either way, and it's individual to the circumstances which is the better route for the tenant. I would advise that if you are unsure which route to take legal advice and discuss all of the options with your advisors so you can decide the most appropriate entity to take the tenancy in. But in short, there's no right or wrong whether you take it in an individual's name or in a company's name. It's just what's right for you in those circumstances. When you have a farm business tenancy, one of the things that the landlord and the tenant should always ensure that they agree from the outset is who is responsible for maintaining which parts of the land. That can be flexible, as we've discussed, between the parties. They can decide whether they want to have an agreement that puts all of the responsibility onto the tenant, or whether the landlord wants to retain some of the obligations as to maintenance. Quite often you'll see it agreed that the tenant is responsible for most of the maintenance of the land and the day-to-day management of buildings, but the landlord might retain responsibility for some things that bring inherent value to the land, or that any tenant would expect a landlord to be responsible for, such as ensuring that there's good drainage and toilet facilities, etc., to any residential buildings included in that tenancy. Entering into a farm business tenancy is a contractual arrangement between two parties. Like with any contract, it has contractual sanctions for both parties, so it shouldn't be entered into lightly. If you're a tenant taking on a farm business tenancy, you need to understand the terms of the document you're entering into and the contractual obligations that you're agreeing to with your landlord. Breach of those obligations can result in the tenancy being forfeited or you being responsible for damages to your landlord. Equally, on the perspective of the landlord, again, you're entering into a contract with your tenant, and if you were found to be in breach of those terms, there could be contractual liabilities for you, again, such as damages